You are listening to Lone Star Community Radio on 104.5 KCZWLP Conroe and 106.1 KZCCLP Conroe and worldwide on irlonestar.com.
Good afternoon. You're listening to the Legal Connection Show, and I'm Tony Collins, your host. I'm an attorney licensed in Texas. I have a co-host, Cheryl Ellswood-Tahani. She's not with us today, but she's with us in spirit. And we're in a new location, I'm excited to say. So I'm sure you've heard this in all the other shows. But you can hear us, regardless of location, on FM 104.5 and 106.1. It's the local Conroe or Montgomery County Emergency Band. And we will be broadcasting between noon and 1 every Tuesday. And today, our show is going to cover a few things that I think are going to be most important to people that might have some family members or personal issues with current criminal charges against them. But we've also got some announcements. And so what we're going to cover is the issues or the different mechanisms and strategies that you can employ or your attorney can employ for you if you have been falsely charged or if you believe that the government has obtained evidence to find probable cause improperly. And we're going to go over 4 different things that you can do to fight that case that you might learn if you hired an attorney. And if you don't have one or your attorney doesn't tell you, or if you have a public defender, you might kind of keep these things in mind. But for our announcements, first off, I just wanted to talk about, and these are not necessarily going to be in order, but we had a big rain yesterday here in Conroe. And on my way home, as I was going down my street, I saw a massive rainbow. And so I just pulled off on the side of the road and I took a picture of it. So I wanted to show y'all, and I think we have a camera right here in front of me, this rainbow. And then I'm going to tell you some interesting information about rainbows. And then I'm going to ask Station Manager Dick, if he's with me on this, some frequently asked questions and see if he knows the answer about rainbows. Okay, so here is, I don't know if you can see this or not, but it is the rainbow that's literally right over my house and my neighbor's house. And it was the full rainbow. It was a double rainbow yesterday. You can see the main rainbows here, but there was a double rainbow up here. And I'm sure many, many people have a picture of this rainbow that was over Conroe. It was just beautiful. And then as we got close to our house, you can kind of see the rainbow is you can kind of see the half rainbow right here, but it was clouding up, and so you couldn't see it as well at that point. Okay, so one thing I wanted to say about rainbows, because they've always sort of been just sort of I think of that Rolling Stones song, She's Like a Rainbow, and I was humming it the whole time I was taking these pictures. Rainbows I didn't know much about, and then one day I just opened the Bible, just sort of cold turkey, and it opened to this passage right around the time I was thinking about rainbows, and I thought it was odd. So I'm going to read it. In the Bible's Genesis flood narrative, after creating a flood to wash away humanity's corruption, God put a rainbow in the sky as a sign of his promise that he would never again destroy the earth with a flood. And that's in Genesis 9:13-17. And I just thought it was interesting that rainbows are, according to the Bible, God's sign that he's with us and he's not going to hurt us and we won't be destroyed by flood. And in Conroe, with all our drainage issues, I think that's good to know that we have rainbows out here. Okay, so here are some just kind of fun frequently asked questions about rainbows. And I'm going to see if Station Manager Dick is paying attention. If he's not, I will ask them and then answer them on my own. So let's see. Why do you see rainbows after it rains? Let's see if Station Manager Dick is listening. I don't see that he is. Oh, you are? Do you know? Yeah. Okay, he doesn't know. Here's why. There's a few things you need to see. There's a few things to see. You need to see a rainbow. The main things are rain. You need the rain to be illuminated by the bright sunshine, and you need it to be in a position that the rain lies on the circle 42 degrees around the shadow of your head. I don't know what that means. So if you get rain from a shower that moves in the direction away from the sun relative to you, then you have a good chance of seeing a rainbow. You are more likely to see a rainbow on days with scattered showers or storms rather than on dull, overcast rain days. And I will say that rainbows are prominent in two places that I've gone on vacation. One is in Hawaii, and they were all over the place at this volcano. We just saw rainbows everywhere. And the other place where I probably saw maybe 200 rainbows everywhere I looked was when we went to Argentina on the border of Brazil and Argentina. We went to, Jim's going to kill me that I can't remember the name of that dam, but they were the Iguazu waterfalls, and they are, I think they're the most beautiful waterfalls and probably the largest on Earth. They make Niagara Falls just small in comparison, but there were rainbows everywhere, and it was like heaven there. And so I'm going to ask Station Manager Dick if he has ever been to a place where there's a ton of rainbows. You haven't? Oh, then you need to go to Wazoo Falls. Or I think even probably Niagara Falls. One thing I learned when I was looking all this stuff up is that there are 7 colors in a rainbow. And so I'm going to ask Station Manager Dick, do you know what those 7 colors are? Or guess a few of them. I'm sure you've seen it. Okay, well, name a few. I bet you get almost all of them. Red?
Green,
Yeah.
yellow,
Right.
blue.
Yeah. You're only missing 3. You've hit all the main ones.
I can't think of
Okay. One is orange. One is indigo. I wouldn't even know what that is if I was a guy. I don't think it's a normal color. And violet. Those are the 7 primary colors. And what it says here on this wiki is we only have specific common words for 7 of the colors, and thus it is commonly known that a rainbow has 7 colors. But of course, a rainbow probably has almost an infinite amount of colors because they transition. Now, this is kind of dumb, but they've got, how do you remember the colors in rainbow? And there's a little mnemonic, and it says, Richard of York gave battle in vain, I guess, if you want to remember what the colors are. I also read that a rainbow is actually a full circle. And let's see, here it says, why are rainbow arcs are semicircles? And since that's kind of a weird answer, I'm just going to answer it. Rainbows are usually only partial, part of the circle around the antisolar point on which rainbows are seen. They cannot be square or straight because of the way rainbows are formed. And that didn't really answer the full question, but rainbows can be a complete circle. If you look at them from a satellite view, it's actually a full circle. And the question they have here are, it can be a full circle, because although it is difficult to produce the conditions for this to occur, it isn't really possible to have a complete circle from a naturally occurring rainbow as seen from someone standing on the ground. However, in an aircraft, you could possibly be able to look down on the water drops in the atmosphere and see a rainbow in the full circle. And I was looking at a few of these from satellites and the space station, orbits or however they take those pictures, and saw the full rainbow circles, and that was kind of interesting. And we had a double rainbow yesterday, and so the question is, why are there sometimes 2 rainbows? Any ideas, Station Manager Dick? Okay, here's your lesson on double rainbows. A secondary rainbow is produced by light which has reflected twice inside the raindrops. The secondary rainbow occurs on an arc 51 degrees around the shadow of your head, whatever that means. And all I know is that yesterday I saw a double rainbow over Conroe, and that was the picture that I showed. And it says, there's also a question is, can moonlight produce a rainbow? And the answer is yes, it can. So I guess you can also see a rainbow at night, but I think it would be really difficult. It must be like right at dusk. And then finally, how far away is a rainbow? A rainbow is caused by sunshine on rain. The rainbow is as far away as the rain is. Rainbows can be seen in other sources of water drops, such as fountains or even dewdrops on grass or spider webs. In these cases, it's easier to know how far away the rainbow is. And then the next question is, can you stand at the end of the rainbow like that leprechaun? And the answer is no, because a rainbow is not a physical thing by itself. When you see a rainbow, you're looking at sunlight that has been reflected through the refractions of raindrops. Let let me see if there are any other questions that are of any interest. Not really. It was just I just thought rainbows are so beautiful, and you see little kids and little girls have them in their bedrooms, and they're sort of methodical like unicorns. But I never really knew that much about them. I just think that they're so beautiful, and I think they're a way that God kind of shows us His presence. And there's actually some tangible history about them, and we've just kind of gone over that. All right, so that was the first thing I wanted to go over was rainbows. Second, there's 3 announcements. Governor Abbott has yesterday announced the end to the federal pandemic-related unemployment benefits, and he made an announcement on his website. And I'm just going to read this just real quickly because it's the governor's press agent actually giving this information out. And I didn't hear a lot about it in the press. Governor Greg Abbott today, which was yesterday, informed the U.S. Department of Labor that Texas will opt out of the further federal unemployment compensation related to the COVID pandemic, effective June 26, 2021. This includes a $300 weekly unemployment supplement from the federal pandemic unemployment compensation program. And this is what Governor Abbott says. The Texas economy is booming, and employers are hiring in communities throughout the state. According to the Texas Workforce Commission, the number of job openings in Texas is almost identical to the number of Texans who are receiving unemployment benefits. That assessment does not include the voluminous jobs that typically are not listed, like construction and restaurant jobs. In fact, there are nearly 60% more jobs open in Texas today than there was in February of 2020, the month before the pandemic hit. So we've got a booming, working economy. There's a lot of jobs out there, and that's why he put this out. He goes on to say in his press release, the current job openings are good paying jobs. According to the Texas Workforce Commission, nearly 45% of posted jobs offer wages greater than $15.50 per hour, approximately 76% more than the $11.50 per hour. Only 2% of posted jobs pay the minimum wage. So basically, this is saying that if you've got a college student that's at home and is not working, or if you are in a program where you're required to find a job, or you've been laid off and you're looking for unemployment, you're going to be hard put to say you can't find one when the governor is recognizing these statistics. So is the Texas Unemployment Commission. He goes on to say in his press release that at this stage of the opening, the state 100%. The focus must be on helping the unemployed Texans connect with more than the million job openings rather than paying unemployment benefits to remain off the employment rolls. Another reason why today's action is needed is the high level of fraudulent unemployment claims being filed. Fraudulent unemployment claims rob taxpayer money and do nothing to help the unemployed. The Texas Workforce Commission estimates that nearly 18% of all claims for unemployment benefits during the pandemic are confirmed or suspected to be fraudulent, which totals more than 800,000 claims worth as much as $10.4 billion if claims had been paid through your tax dollars. Federal law requires the effective date of this change to be at least 30 days after the notification to the Secretary of Labor. As a result, the effective date will be June 26, 2001. So that's our first announcement that Governor Greg Abbott has looked at the Texas unemployment situation and the number of jobs that are available. And he's made it really difficult for people that aren't working to have an excuse for not finding a job and trying to collect money and sit at home. All right. Next, taxes to file your federal income taxes. The President Biden extended your filing tax deadline from April 15th to May 17th, which was yesterday. So if you didn't get your TurboTax and they were out of the disc at Target and I believe at Sam's, you could get it online. If you didn't file your taxes and you owe money, you still have a chance today, the sooner the better, because it's only the 18th, to file a Form 4868, which you can do online. It's to extend your deadline to file through October, I think it's 18th or 17th, but you'll see if you go to that form. So you just say filing tax extension for 2020, and usually Google brings you right up to the IRS.gov website page that allows you to open a one of those forms that you can just fill in the blanks. And there's only like about 4 forms you fill out, and you can mail that today. It should have been postmarked by yesterday, but I think that they'll give you a grace period because of the pandemic and this unusual situation. But do file that if you needed to extend because you couldn't get the TurboTax, or your account was busy, or maybe you forgot. Okay, the next announcement is that Harrison Montgomery County courts are now opening up for jury trials in person, and jury duty is now not something that has been postponed because the pandemic severity is now ending. And so let me see here. In Harris County, I know this because I've got lots of cases coming up in Harris County. They're still picking juries at NRG, but the courts are no longer postponing the trials or setting them out because we can't get juries in person. While they're still picking them at NRG, the judges are now setting the cases that have been postponed for the last year, regardless of whether you have to go pick them at NRG. And that's for Harris County. In Montgomery County, you can actually register if you didn't get something in the mail, you can register through the Montgomery County District Clerk or County Clerk website. And if you go to that website, if you haven't received a summons in the mail, let's just say that you feel like you want to serve and it's your duty. What it basically tells you on that site is jurors are randomly selected from a database that combines information from the Montgomery County voter registration list and the Texas Department of Public Safety identification certificates. It goes on to say that jurors may be selected to serve in the district courts or the county clerks at law. You can use the online services if you want to learn more about it under the jury frequently asked questions or the e-jury service. You can fill it in, or you can call the jury supervisor, Brenda Shank, at 760-9652. And in my experience, whenever I've called Montgomery County about information about jury duty or pretty much anything, they are very good about answering the phone and you talking to the people that are in charge. And when I've done frequently freedom of information requests online to get information about just about anything, about subdivisions going in, or maybe an arrest, or information about a ticket, for a case I'm doing, or any number of things. When I've submitted those things online, they are amazingly prompt and helpful in providing the information that you need. And so I'm just going to kudos to Montgomery County, where I've not been always satisfied with my jury verdicts and the way some of the judges rule in my cases. That this goes to the facts of the case, or maybe a number of things, maybe a bias, or how rich your opponent is and how well they know the judges and that kind of thing that might kick in. But as far as the county administration personnel, they are absolutely superb, and I just am giving them a shout out for that. All right, so our topic today is actually something that I hit on earlier in the show, and will be beneficial to people that have been charged with a crime in any court in Texas. But I'm really going to focus on some examples that I've experienced in Montgomery County and Harris County. And this goes toward when someone's been charged, you or a relative, somebody with a crime, and you feel like that the charge can't stick because you've watched a number of shows on TV. We've all watched them, Law and Order, Dateline, murder mysteries, and what have you. Or maybe you just remember some of the laws from your constitutional class or government class in high school or college. But you wonder, why am I going to trial and why am I paying this much money? Or why is my attorney, whether it be a public defender, paid or not, why are they not trying to get rid of my case in a more efficient manner? Because my constitutional rights were violated when I was arrested, or the charge can't stick. And so we're going to go over 4 different tools that can be employed that you may not know about that can be helpful to you in the future, or maybe when you're watching a crime show, you might be able to understand it better. Okay, if you're charged with a crime or one of your loved ones, if you've charged with a misdemeanor, then you don't have the opportunity to ask for a grand jury to review it before it goes to court. And I think we've gone over grand juries in other shows, but if you've got a felony, it's such a serious offense that the Texas statutes provide that you cannot. Probable cause is not just found by the felony district judge where your case has been filed and accepted and where it landed, because it could be you don't know what court it's going to land in. Of course, in Harris County, you've got I think 40 different criminal courts it could land in. In Montgomery County, far fewer. You may have 3 or 4 district courts. So your odds, you know your judge is going to be, your odds are going to be better than buying a lotto ticket for you knowing which court you're going to land in. And but in any case, it's the same in all counties in Texas. If you're charged with a felony, your case must be presented to a grand jury for them to find probable cause within 90 days of the filing of that case. And if it's not, and you're still in jail, then you need to be released on a PR bond. And even then, it may be a cause for you to ask for it to be dismissed because you haven't had your right to a speedy trial being addressed. Usually your case goes on a calendar in the prosecutor's office, so they know when they need to bring it to the grand jury for it to be indicted so they don't miss that date. But let's say that as far as the grand jury, you want to fight it on that level, then you can do a grand jury packet, and we're going to go over how that works briefly. The next category that we're going to discuss is examining trials, and examining trials are not used that much in Texas. I haven't seen that many, more so recently. Examining trials are a mechanism that your attorney can use for you to present your case to a judge in misdemeanor court or in felony court. In felony court, it's usually in lieu of a grand jury presentation, but in misdemeanor court, your attorney can ask first before it's even put on the docket sheet for you to get the full run of discovery being done and what have you, because there may not have been probable cause, and your attorney may know that right off for various reasons. And we'll go over the times when you may want to ask that your attorney look into moving for an examining trial rather than going forward with the standard procedures with getting discovery and being put on the docket and waiting for your case to actually be set for trial. The third thing we're going to discuss is motions to suppress. Motions to suppress are another vehicle for probable cause to be examined once the judge is determined after your arraignment that probable cause exists. What happens is the judge doesn't have all the facts at that short arraignment. They're just basing the probable cause determination on what the prosecutors are saying. And your attorney, if you have one at that point, the arraignment happens almost immediately after you're arrested, and sometimes even while you're in jail when you have that little like a video court with the magistrate judge. There's not a lot of time to argue your probable cause, and if it's something like stealing from Walmart and they say that they got you on video, there's very little time for you to argue probable cause, and they're just going to find that. In fact, today I was listening to a live stream, and it was really, it kind of tickled me because there was a guy before, I can't remember the judge's name, Judge Singer, David Singer in Harris County. I love that judge. If you want to get an education on the criminal justice system and how judges think, just listen to Judge Singer. Just go onto his live stream and watch it. He talks about kind of the background information. He's really funny. He's really fair. I love this judge. And he had a guy before him today that he was being arraigned for stealing cologne from, I think it was... I can't remember which store it was. I can't remember right off. It was some store that sold cologne. He sold 3 bottles, but he was also under. He had a pending case for stealing cologne from maybe a year ago when the pandemic hit that hadn't been gone to trial yet, and he stole that cologne from. I think it was maybe from Sears. I didn't even know Sears was still open, and then he had already been convicted of stealing cologne yet from another store in 2017, and it's his only thefts for stealing cologne. It was like it maybe, and the prosecutor was saying, well, maybe he just wants to smell good, but he still stole it, and it was really sad because the odds are he probably stole cologne because he wanted to smell good, and it didn't seem like he had a fetish. It just he was working as a day laborer and he got jobs if he hung out in front of Home Depot, and it was kind of sad that he kept getting picked up for stealing cologne. You'd think he would have learned, or maybe there might have been a different method of getting cologne, but this is what he was indicted. He was being charged with, and probable cause was found. This is the type of thing where he might be able to find a motion to suppress. I don't know what it would be right off. I don't know his case, but the probable cause was found in that case, and all 3 of them of the charges against this guy, and a motion to suppress might be a way he wants to go. The third type of activity that your attorney can employ to, I guess, for probable cause to be not found, if a grand jury found probable cause and the magistrate judge found probable cause, and and let's say you went to an examining trial and the judge still found probable cause, and your attorney even moved to suppress, and the judge still found probable cause because it wasn't granted. And I've moved to suppress many times, and I'm going to go over a few of the examples. But when the judge won't find in your favor, and you just don't, and there's just no way that you know that you can win in front of a jury if you can just get that constitutional question in front of them. And I didn't even know that you could do this until I was actually in a Montgomery County pretrial, and I had stopped my good friend Joe LaBella, who died 2 years ago, and I still am just so thankful for his life and him giving me these tidbits of information when I would just, desperately stop him in the hall and ask for his help. And, in the courts when I just didn't know what to do, he would be there for me, just like an angel coming out of the clouds. He'd show up in his New York way. He'd say, here's what you need to do. And it would always work. And so he had told me, like, maybe, I want to say it was maybe 8 years ago, he was watching me in this pretrial, and he had helped me with this, with a case. I'm not sure if he really helped me with this one, but I kind of gave him the Cliff Notes version of it so I could figure out how I could get this in front of a jury. And he said, you want to make sure that they're in the jury charge that there is an instruction under the Texas Criminal Code of Procedure, statute 38.23. And I didn't even know you could do that to get a constitutional issue before the jury, instead of just, do you believe he's guilty or innocent? And it is invaluable. Not enough attorneys ask for it, but basically it's an instruction to be included so that the jury can decide if there's the evidence that should not be brought in because the government improperly obtained it. And so you've got kind of 4, bites at the apple here to show that there wasn't probable cause, and your last one, is in front of the jury. And of course, if your jury doesn't find in your favor because this instruction either didn't make it in because there was an error and, the judge ruled the wrong way, you can still appeal. And again, I need to bring up my good, late, amazing friend, Joe LaBella, because I had a case that we were not allowed to put this in jury instruction in. We did not believe that the government fairly obtained evidence. It should have been suppressed from the jury. And there were some other things that happened in trial that just didn't seem right. And so Joe LaBella helped me and my client to move for a new trial, and the judge dismissed the case at that level. So there was still sort of a 5th bite at the apple that he had determined that maybe, some things that didn't quite work right. And a county judge down here in Montgomery County did the right thing and dismissed the case. So never say never. If something's not right, you can just keep working on it. And if things don't go your way, don't give up. Okay. So on each one of these particular methods and vehicles for probable cause to not be found, so your case can be dismissed, we're going to go over them just briefly. And so I'm going to ask Station Manager Dick, how much time do I have so I know how I can coordinate this?
25 minutes.
Oh, perfect. That's about what I need. So about 5 minutes on each one of these areas, because I think that if anybody is experiencing a criminal case and it's pending and you're just beside yourself because you've been falsely accused, or you weren't falsely accused, but the evidence obtained by the government was improperly obtained, and you believe that your case should have been dismissed long ago. These are kind of the way that you can go about before going all the way through the expense of a jury trial, which is very expensive and draining for everybody. And you just never know how a jury is going to decide given the evidence that you have. You just don't know. I mean, you could have, if you've got a really, hardworking but not particularly handsome or beautiful client, and then the person that's the complaining witness, is dastardly, but beautiful or, well established and rich. The jury looks at that. And a lot of times whether they say it or not, they're biased, and they will find in favor of the rich guy or the prominent guy or the beautiful girl, even if they lied through their teeth. And, because you weren't able to bring all your evidence in to show their lies. So here's some things you can use. Okay. So on grand juries, here's what you need to know about grand juries. The function of a grand jury is to accuse. Let me repeat this. I'm reading this from Grand Jury Wikipedia. The function of a grand jury is to accuse persons who may be guilty of a crime, but the institution is also a shield against unfounded and oppressive prosecution. And I don't know why Wikipedia has it phrased like that, because that's really confusing. The function of a grand jury is to determine whether there's probable cause for a crime, and it can be disposed of at the grand jury level if they find that that a probable cause cannot be found, even if the judge already found it. It is a means for lay citizens, representative of the community, to participate in the administration of justice. It can also make presentments on crime and maladministration in its area. Traditionally, a grand jury numbers 23 members. Well, in Harris County, it's actually 12 members. I thought it was much more, but after talking to some prosecutors, and maybe it's because of the pandemic, they have a number of citizens that are brought into the jury pool. And I don't know if they're segregated out, but they're asked if they want to be members of a grand jury. The grand jury usually meets twice a week. The prosecutors have a stack of evidence that they present to the grand jurors, and the defense attorney may not be present. They can say nothing. You do not even know what's being presented to the grand jury. So that's sort of the con to it, is that you're glad it's being presented. And if you can present a grand jury packet and present it to the prosecutor, you hope that the prosecutor can see that they don't have a case based on what you've presented. But you also hope that even if they disagree with you and present it, that the grand jurors will see that there's no case. And I've had a number of cases no billed at the grand jury level by doing what's called a grand jury packet. And the grand jury packet basically allows me to present my client and their background, my version of things, not just the charge as read by the police affidavit, which can be very biased. They're not usually showing them the police body cam. It's just statements that the police are taking from the complaining witness, which can be completely wrong or completely biased if they haven't done an investigation. So you're hoping that what is presented to this grand jury will get your case no billed, so it saves everybody money and everybody can relax and you don't have to go forward. Basically, kind of pre-trial. And I had a case with a guy named Jose de la Vega, and it may have been 12 years ago. And these are the kind of cases you want to bring to a grand jury. He was accused of of trafficking drugs, and but he didn't. He was a plumber's helper, real nice guy. They allegedly had found cocaine in his shoe, in a locker, in a locked room, in the place where he worked, and they said it was his. And they had, it wasn't. Ultimately, he said it wasn't his, and I'll tell you how I got it no billed. But for that kind of far-reaching accusation with little or no connection between this alleged cocaine and where they found it in my client was absurd, because I don't think they really even had lockers in this particular area off of Hardy Toll. And so I did a grand jury packet, and I had my guy drug tested to show that he didn't do cocaine. And with that amount of money, it would have shown in his system over a month for the drug testing that we did. I actually had to go to jail and ask for a motion for my drug tester to go in there and test him. Did the grand jury packet, and he was no billed about a month later. I had another one that I did for, I can't remember his name now, but he and his girlfriend, she was 16 years old, and he had just turned 19. He was just a month out of the range where he was safe, because if there's a 3-year difference between teenagers and one, and they're like in high school and they're having sex, you have a statutory rape situation if you've got an adult having sex with somebody under 18. If you're not married or you don't have their parents' permission. And we all know that many, many kids are in high school, especially 19 and 16-year-olds are having sex, whether we want to admit it or not. That's what's happening. And if you have a 15 to 18, even that's a little bit dangerous. But in this particular situation, these two people were dating. The guy had been dating this girl's older sister, but broke up. The older sister was heartbroken, told her mother about it. He started dating her younger sister, who was, well, I take that back. This other girl was much older than him. She was 29. He was 19. The younger sister was 16. So it was a big span in age. The mom was upset because he wanted her to marry the older sister. And I was able to get with the younger sister and get an affidavit without the mom knowing, to say that it was consensual, and that they, actually, I didn't. I got an affidavit from her saying nothing even happened, and that's what they were telling me. I don't believe that, but there was no evidence they were having sex. It was just the accusation that the mother made to the police. Ultimately, my client married this girl. Since it was so long ago, they're now she's in her late 20s, I think, and he's in his late 30s. But he had gotten back with me. Is it late 30s? I take that back. Late 20s, and he's in his early 30s, because they were only like 3 years apart. He got back with me. They have 3 kids. They're doing very well. They live in New Jersey. He asked me to expunge his case for him because the statute of limitations had passed. You have to wait a while after your no bill before you can expunge it. We got it expunged, and he never had any other issues. The perfect person for a no bill. So that was a big success on our part. I had another one recently that I sent to a grand jury. It was very recent. I was infuriated because the prosecution in Harris County presented my evidence to the grand jury, but didn't present the actual evidence that showed that there was no probable cause. Because in this particular case, my guy was accused of date raping a girl that he met at a bar. And what really happened was the girl went to the bar with the intent of picking someone up. And so the video evidence shows that she was the instigator. She was following him around. And then I got the lab information that showed that she wasn't drugged. And I got statements from everyone in the hotel saying that basically she was seducing him. So I had all this evidence showing that she wasn't date raped. She wasn't raped at all. In fact, if anybody was raping anybody, it was this girl to my client. And then there wasn't any DNA evidence that showed that there was any rape. So I had all this evidence showing that this was a false charge and this girl was lying. And particularly the videos from the hotel that I got, the surveillance videos that actually captured everything that was going on at the bar and in the hotel, well, not in the private room, but enough to show that she was the instigator. And the prosecution didn't provide that information to the grand jury. And she admitted as much. And when I asked for the grand jury transcripts to prove that that was improper by the prosecution to present this evidence, to present a grand jury file case to the grand jury but not provide my packet and the actual video evidence. The judge, I actually went for the judge with it, and he said, well, they don't record them, and so you don't have any evidence to support. She didn't do that other than her statement. And I thought, I can't get anywhere with this. And I was just so angry that justice wasn't being done. And so ultimately, I was going to prove that this girl was a liar. And so I subpoenaed everybody in her friends, family, anybody I knew to show that she had a history of doing this. And then the prosecution got back with me a week or two ago to let me know that she didn't want to go forward with the case. And so it got dismissed. So it got dismissed because I didn't let up, but don't give up if you're indicted, because if someone's lying and you rather than them sort of trying to extort you into giving them some kind of settlement money, or, them trying to get $25,000 from the victim's assistance program in the state, or, and in this case, I think she was trying to extort her employer or the hotel. I'm not sure what she was trying to do, but she was trying to make some money off this phony case. Don't give up. Your attorney should go forward and subpoena these people for trial and get a trial date as soon as possible. And it may work out like it did for me. I've got another case that's got a grand jury packet that's going forward that has not been presented to the grand jury yet. I fully expect this one to be no billed. And if it goes to trial, they'll certainly lose because there's no evidence of any crime. It was simply a fight between the two parties and mutual disagreement that was made into a family assault. The person that it was the complaining witness has recanted and said nothing happened. And they haven't no-billed it yet. So the prosecution, I think a lot of times they want to go forward and they're just trying to do their job, but they may be a little overzealous. And so you just, as a defense attorney, have to do the best that you can for your client. As a client, just be patient because justice should prevail if you're doing everything that you should do, including going to Mass and praying about it and having your client go to Mass and pray about it as much as possible. To kind of to finish up on grand juries, no indictment or presentation can be made except by the concurrence of at least 12 of the jurors. So no matter how many people are on that grand jury, at least 12 have to agree to an indictment. The grand jury may accuse upon their own knowledge, but it is generally done upon the testimony of the witnesses under oath and other evidence heard before them. And I have asked for the last 15 years for Harris County and in Montgomery County that I be able to present my witnesses and to let me know when they present it. Not once have I been allowed to present my own witnesses. So it's pretty much just the prosecution putting their side in. Grand jury proceedings are, in the first instance, at the instigation of the government or the prosecutors, and ex parte, in secret deliberation. Almost impossible to get to those grand juries and their record, especially if they don't record them. And I asked for mine to be recorded, and I never have gotten a transcript. The accused has no knowledge nor right to interfere with their proceedings. If the grand jury finds the accusation is true, which is usually drawn up in the form of the prosecution or an officer of the court, they will write upon the indictment the words "true bill," which is signed by the foreperson of the grand jury and presented to the court publicly in the presence of all jurors. If the indictment is not proven to the satisfaction of the grand jury, the word ignoramus, I didn't even know that was a word. I thought that was just something we used in high school, or what that means in Latin, not a true bill, is written upon it by the grand jury or by their foreman, and then it is said to be ignored, and the accusation of the dismissed is unfounded. The potential defendant is said to have been no-billed by the grand jury. If the grand jury returns an indictment as a true bill, and that's in Latin, billa versa, the indictment is said to be founded, and the party to see indicted is required to be put on trial. And I will add, just as a footnote, that if the grand jury no-bills, I believe the prosecution can present it to them again. They can bring the charge again if they get additional evidence. So you're not off the hook completely. But I found that once it's no bill, the prosecution is usually too busy to go forward with it, or something else kind of kicks in. Rarely, unless you've got these really big murder cases, do they bring it back for a second shot at the apple if the grand jury gives you a no bill. All right. The second vehicle that you can use if you're trying to get your case to be dismissed prior to actually having to prepare and go to trial is to motion for an examining trial. These are primarily done in misdemeanor court, from my observation, because you don't get the bite at the apple at the felony court, like you're required to by statute in felony court. But you can also do examining trials in felony court. The statute that you want to read, if you don't know anything about it, is the Code of Criminal Procedure, Texas Code of Criminal Procedure 16.01. It's a real short statute, but the bottom line is when the accused has, and I'm reading from the statute, when the accused has been brought before a magistrate for an examining trial, that officer shall proceed to examine into the truth of the accusation made, allowing the accused, however, sufficient time to procure counsel. In a proper case, the magistrate may appoint counsel to represent an accused in such examining trial only, and to be compensated as otherwise provided for in this code. So you have to be indigent if you get a court appointed. The accused in any felony case shall have the right to an examining trial before indictment in the county having jurisdiction of the offense, whether he be in custody or on bail, at which time the magistrate at the hearing shall determine the amount or sufficiency of bail, if it's a bailable case. Usually they'll set a bail unless you've proven that you will not come back on a bond, so you're not going to get a bond. You're going to skip the country or whatever, like that gal up there in the Epstein case. They're not giving her bail because she's rich and she could bond out and leave the country to some place that wouldn't extradite her to the U.S. To face trial. If the accused has been transferred for criminal prosecution after hearing under Section 54.02 in the Family Code, the accused may be granted an examining trial at the discretion of the court. I will say this about examining trials. I like them rather than a grand jury packet. If you know the court that you're in, the prosecutors are not going to present the packet that you have. This is your opportunity to actually show the facts that you've collected to a judge, and you know it's going to be presented because you're actually providing it to the judge in a court with a court reporter. So the examining trial takes the place of the grand jury, and you can actually participate. The downside is it is more expensive than a grand jury packet, and it's like a mini trial. But not to fear, if you go to the examining trial, and I've watched a few of these live stream, and I don't see them all the time. Again, they're like a mini trial before trial. The high point is you get to actually present it. The downside is there could be a high expense. But if you lose the examining trial and the judge finds probable cause, don't fret, because in order to be found guilty, it has to be beyond a reasonable doubt, which is a much higher standard. And you can still go to trial, or you can file a motion to suppress, which is another opportunity for you. And on my case where it was indicted, where the prosecutor didn't provide the information to the grand jury that I'd prepared, and it showed that there wouldn't have been any probable cause, I should have asked for an examining trial. But the problem was I had trusted this prosecutor and had worked with this court before and just read them wrong, and believed that they were going to properly present my case, and they didn't. So if you question your prosecutor or are not trusting of the court, examining trial is the way to go. Okay, the next vehicle, the third one that we want to talk about today, is the motion to suppress. The motion to suppress is something that you want to file, and you can file it at pretty much any time after you've been charged. Generally, the motion to suppress is something that you file after probable cause has been found in the court, through the examining trial, by the magistrate, or to the grand jury. And it's something that you see quite a bit argued. It's usually a constitutional issue that will get it dismissed. I see many of these granted. I'm going to tell you what it is. It's the actual definition. A motion to suppress is a motion that revolves around the exclusion of evidence from trial. In the United States, a motion to suppress is a request made by a criminal defendant in advance of a criminal trial, asking the court to exclude certain evidence from trial, usually because the Fourth Amendment or one of your constitutional rights has been violated when the evidence was collected. So you're asking the court before trial to exclude evidence. And generally what happens is the evidence that you're asking them to exclude is so important to the trial that the prosecution cannot win if it's excluded. Most of these motion suppresses I've seen in DWI trials, they go toward whether a police officer had the right to stop you and arrest you based on a light that was out in your car, or they're saying that you changed lights without using a blinker, or you were speeding. That's a big one. How would they have known you're speeding? You wouldn't even have been stopped had they, unless you were speeding, but they can't prove it. Therefore, they had no reasonable suspicion to even arrest you. If short of that, I see a lot of cases that are the motion to suppress is granted and the case is dismissed because the DWI is one of the speeding cases. They can't prove it. If the case is felon in possession of a gun, but the gun was, under the passenger seat and they shouldn't have stopped them because they were being cooperative, whatever the reason may be, they didn't have a reason for the arrest. There was not enough evidence. And if you can suppress that evidence, anything that happened after that evidence was obtained or that improper stop cannot come in, and then the case will be dismissed, even if you're guilty of what they charged you with, driving while intoxicated and what have you. I had a case with my defendant, Mr. Luna, about 10 years ago, and he was, 3 strikes you're out. It was a case I did for free. I just didn't even see that there was a chance in, Hades, to win this case. But he was so empathetic. I was so empathetic to his case, and he really wanted so badly to for me to help him. And I thought, well, I'm going to give this a shot. He had been in prison before several times, but he explained to me that his prison cases, when he explained, and this is just somebody I met when I was doing I was in the jail area of the court talking to another client, and you normally don't talk to other people back there. We didn't have an attorney. He begged me. So I listened to his case. I was very sympathetic. He basically was stopped because he did shows over there outside of downtown in the district that's now where the soccer stadium is. And he went to go get some ice, apparently. And when he drove over after putting together this show or something, he had a bunch of cocaine in his car. It was under the floor mat. And when he told me that, I thought, well, how would they have even seen it? And ultimately, they did an inventory search incident to arrest because there was a warrant out for his arrest for a ticket. It was something really small. I was able to argue U.S. v. Gant, which was a Supreme Court case that said the police cannot do a search to your car unless they've got probable cause or incident to the reason that you were being arrested. He was being arrested for a warrant for a speeding ticket. He had gotten someone to pick up his car and drive it, so there was no need for an inventory search. I argued that, to the high heaven, and the court had already made me pick a jury to start trial the next day. That my motion to suppress was granted, and the case was dismissed based on U.S. v. Gant. So there's all these different. His Fourth Amendment right was violated, so that won. And so there's different ways you can go about it, but do look at the motion to suppress as a way to get around having to go to trial. Finally, I'm going to hit on this one topic, and that is that you want to ask your attorney to put in Criminal Code 38.23, a jury instruction for evidence not to be used, and for the jury to determine if there was a constitutional breach when the evidence, like a motion to suppress, but the jury gets to decide it. Have this jury instruction put in. I've used it, like I said earlier in the show. Joe LaBella told me to use it. I've used it many times. It's a very, very important jury instruction to put in. It's real short. It basically says it asks the jury to determine if evidence was obtained by an officer or another person in violation of any provisions of the Constitution or laws of the state of Texas or the United States that shall be admitted into evidence against the accused on the trial of any criminal case, that it should be excluded, and in any case where this legal evidence raises an issue, the jury shall be instructed that if it believes or has reasonable doubt that the evidence was obtained in violation of the provisions, then in such event the jury shall disregard such evidence as obtained. And if that's the case, it was constitutionally improper, the jury would be able to find that there was not probable cause, and you should be able to win your case without them even looking at the additional evidence coming into trial. Juries a lot of times have made up their mind before they've even seen that instruction, but it's something that they need to look at, and without that instruction, they won't even look at it, so you need to do it. And I will add before in closing, because my time's pretty much up for today, that if you have any questions about today's show, that you can go and listen to this podcast on YouTube by Googling thelegalconnectionshow.com, or you can go on IR Lone Star. They keep recordings of all of our shows. Or you can go to our Facebook page, which is also called thelegalconnectionshow.com, and it'll be posted there. Next week, we're going to have a special guest, my very good friend, Fran Cartafalsa Miranda. Went to high school with her. We're going to go over some history. Her mother is one of the remaining descendants of the Stoneham family that founded Stoneham, outside of Conroe. She grew up in Conroe in the 30s and 40s. She's going to give us a little history. We're also going to go over some of our teachers from Sharpstown High School that have been, there's some lore to their, what they've done with their lives. Miss Copeland, Joyce Frazier, and Miss Pam Connor, who's Dan Pastorini's girlfriend. All of them taught at Sharpstown High School. They're amazing. They're still around. They still, give to the community. Of course, Dan Pastorini was the quarterback for the Oilers during the Love You Blue stage. So we're going to talk about those things next week. So tune in. We're going to talk about Love You Blue, Dan Pastorini, Stoneham and Conroe lore, and some of the things that happened back then. Tune in again to listen to us at 104.5 and 106.1 FM. And remember to serve God by serving others, and we will see you next week.